Some Igbo leaders, even when the case was in court, went to prevail over President Buhari for a political solution. Were they sub-judice then? I'm talking about those Igbo leaders.
Yeah.
Recently, we've heard that governors like Alex Oti and a couple of other governors, I think governor of Imo State, have been talking to the president about a case currently in courts. Can we also deem those as sub-judice?
Hello everyone and welcome. Welcome back to Oba's Trending Gist. Today we are dissecting a recent episode of the Arise News Morning Show that sparked intense debate across the nation. The panel tackled everything from Nnamdi Kanu's high-stake defense strategy to the controversial ruling shaking our judiciary, from surprising witness list in a prominent legal case to a shocking court order for forced marriage. The discussion reveals deep-seated questions about justice, freedom, and the rule of law in Nigeria. Get ready for an unvarnished look at this pivotal moment. Sit back and take a watch.
Barely 24 hours after the protest, the detained IPOB leader Nnamdi Kanu, in a motion he personally filed on Tuesday, October 21st, agreed to enter his defense and informed the Federal High Court of his plan to call a total of 23 witnesses divided into two categories. Well, among those listed as compellable witnesses are former Minister of Defense, General Theophilus Danjuma, former Chief of Army Staff, General Tuko Boratai, FCT Minister Nyesom Wike, Works Minister Dave Umahi, Governor Babajide Sanwo-Olu of Lagos State, and Governor Hope Uzodinma of Imo State. The detained IPOB leader told the court he would testify on his own behalf, providing a sworn account of the facts, denying the allegations, and explaining the political context of his statements and actions. He requested a 90-day time frame to conclude his defense, given the number of witnesses. I mean, Rufai, what a dramatic turn of events. You know, Kanu's lawyer has been remanded in Kuje Correctional Center for participating in the protest. The timing and Kanu's decision to personally sign the notice raised questions about his relationship with his legal team and suggest a significant strategic pivot in his defense approach, potentially signaling his readiness to confront, the charges directly after years of legal challenge. People would say, he had no choice. Right now, his lead counsel is in detention. He has to, I believe he also is a lawyer, he says, Nnamdi Kanu. I've said some places that he said that.
You see, if we want to build a nation, let's build a nation. If we want to be hypocritical, let's be hypocritical. For all of those that are saying Ejimako has no right of protest, and I'm not a lawyer, so please, you can challenge some of my thoughts, but I'll think freely on this. And they are claiming sub-judice. We have all been on this table where many cases that are currently in courts have been come to discuss here. Do you remember? Can we even go back and point out a couple of things? Anyway, we remember the debacle of Natasha, and we remember how people were coming to discuss the case while even the judges said they shouldn't discuss it here. Do we remember? Why didn't the legal disciplinary committee, why were they called in then? This case it's been on for a while. You remember that at some point during President Buhari's administration, some Igbo leaders, even when the case was in court, went to prevail over President Buhari for a political solution. Were they sub-judice then? I'm talking about those Igbo leaders.
Yeah.
Recently, we've heard that governors like Alex Oti and a couple of other governors, I think governor of Imo State, have been talking to the president about a case currently in courts. Can we also deem those as sub-judice? So please, I don't know anything in law, but I just think out loud. So please, you can educate me. I'm open to education.
We will learn more.
No. So I want to learn.
A huge debate.
No. And that's why I'm asking. And I've cited my position that were these engagements sub-judice, the one that the great elder statesman from the South is that even finally passed after that, negotiation with President Buhari at an early, was a former federal minister in the 60s in this country. They went to President Buhari to ask and beg that Nnamdi Kanu should be released political solution. The governors have been talking to the president as regards that. Are these also sub-judice? Because when you say, okay, Ejimako went to protest about a case in court and you say, okay, sub-judice, you should know better. Now he's been detained and, he's been taken against his right. We forget he's a citizen first. Well, those other instances where they sub-judice. That's just what I want to. And please, let's also put a background on this case. We've also had a court in this country that have said Nnamdi Kanu did no wrong and should be discharged and acquitted, and appeal courts, before this case had been taken to the Supreme Court. So let's also put that in the context of this conversation. All right. Nnamdi Kanu said he wants to go ahead with his defense process. Yes, he has a right, but also it's only incumbent on let's even make a verification if he was the one that listed these people out. And let's make a verification on that process that was said that came from him, and let him go through his defense. A man has a right to be able to defend himself.
Right.
I am not saying that we should not, have a definitive stance on the rule of law in this country. But all I point out every day is the hypocrisy.
The selective application.
I mean, there are people now that we see them carrying guns and everything, bandits, having peace meetings and all that. Nobody have arrested them now. Okay. Their matter is not in court, it's not sub-judice now.
All right.
So that one is out there. Then secondly, we have also seen people that were pardoned, bandits, criminals that were pardoned. All we're also saying is the political solution that you feel was good for the bandits that people speak for, give it to this man and charge him that if any other thing is done again, then actions will be meted out. That's all what a lot of people are calling for in this regard.
Yes.
That's just it. So if you call him all sorts of names, you call him a terrorist and everything, but you've done it for some bandits in the past now, why is it so different?
All right.
That's all I'm asking. All right. I'm not saying I support the way he went about it. I'm not saying I support all his abuses.
All right.
You did the same process people are saying do for this man, for other people that we saw. You even rehabilitated them. Like Dr. Bati said, you give them ashwebi and jollof rice and pepper soup. These are people that carry gun. No? I'm not sure Nnamdi Kanu ever. Did you ever say any gun is not going to shoot people? But these are even people that carry gun. No, that kill them.
Criminals.
That criminals that committed heinous crimes. So
all right.
You gave them a waiver and you said they should be good members of society again. All we are just saying is for the sake of balancing and for the sake of let's have fairness.
All right.
Let that same thing be done to Nnamdi Kanu, and let's also charge him that all the insecurity there that people attribute to you, let it stop.
All right.
So that at least when Nnamdi Kanu is out of the picture, anybody that does this thing again, we say, okay, we know this is criminality. That's all I'm arguing.
The names that he mentioned, though, as compellable witnesses, I mean, I wonder how that will play into his, defense and all of that. He's asking for 90 days. I believe the last time there was a ruling by James Judge Omotosho, he had said that Nnamdi Kanu should, conduct his case within 6 days. So I don't know. I mean, he's now asked for 90 days. It seems like another extension. But yesterday was this Free Nnamdi Kanu protest, and there were many dimensions to the protest. We saw a clergyman calling out notable pastors, including Pastor Enoch Adeboye, as well as Pastor Tunde Bakare, saying that instead of enjoying tithes and offerings, they should be present at the protest. Well, the same priest was seen running and taking cover after police dispensed tear gas. Let's take a look.
I've come as an Episcopal Lord. I was expecting to see my colleagues. I've not seen anyone yet. I've not seen Pastor Adeboye, Enoch. Crazy. I've not seen Pastor Tunde Bakare. Pastor Tunde Bakare, where are you? You came to the streets to dislodge Goodluck Jonathan for his good economic policy, social reform. You people knock him out of Asura. And today, one man, the country is on that stage. And you people are busy. You are enjoying your tithe and offering your church. Come out and speak for justice. What did God Almighty say? I do not delight in your tithe and offering. I do not delight in your burnt offering. Justice is what I ask you. They are shooting. They are shooting.
I'm sorry, I have to out you, Rufai. Rufai has been cracking up. Is it your constituents or constituency?
No.
Both of you.
Yes, they are big pastors.
They are big pastors.
So
but you know, he did make a valid point. And I think the reason why he called those people was because they were out during the time of, you know, those protests. I mean,
I said
you shouldn't comment. Okay, 30-second comment.
Thank God you recall that they came out in their youthful days. Has anything changed?
No.
Pastor Adebo is 83 years old. Pastor Bakari just turned 70. Let the youth go and use their strength to protest because of the altar. Because they've done their own. And I mean, I think that maybe we should call the younger ones to now take on the baton of defending and going out there to protest. You can protest in many ways. You don't have to go on the street.
Yes, it was just that funny part where he was.
No, that was.
He should have stood with his full chest.
I applaud him coming out. I applaud him coming out to express his right as a citizen of Nigeria. It was very good.
Absolutely, absolutely. Well, all right. Well, let's now turn to the Nigerian Senate, where a heated clash occurred on Tuesday, October 21st, between Senate President Godswill Akpabio, Senator Adams Oshiomhole, and Senator Natasha Akpoti-Uduaghan regarding a controversial abortion clause in the Criminal Code Act Amendment Bill 2025, which aims to strengthen laws against sexual offenses, including prescribing life imprisonment for child defilement. The dispute arose shortly after the Senate voted to step down the bill for further deliberation. Senator Akpoti-Uduaghan attempted to reopen discussion on a sensitive abortion-related clause, prompting immediate objection from Senator Adams Oshiomhole, who rose point of order, arguing that it was against parliamentary rules to revisit a matter that had already been concluded by the Senate. Let's take a look before we come back for a discussion.
Those in support say aye. Those against say nay. The ayes have it.
Mr. Senate President, please may I speak? I'm a woman and abortion has to do with women. It's very important, sir.
Let us go to clause. This has been stepped down in totality. You see, Senator? This has been stepped down in view of the conviction, but if you have anything to add, you can say.
Thank you very much, sir. Senator Natasha Akpoti-Uduaghan, Kogi Central. Sir, this borders on abortion. And...
Yes, Senator.
Mr. President, we have been tutored over and over that when a matter has been concluded and you have dropped the gavel, in this particular case, to allow for more conversation, if you grant exemption to distinguish to Natasha, then you must extend the same extension to us, in which case our rules will become meaningless. I think the rules should be obeyed. We have said more discussion, which allow her to make any input, and I also intend to make more input. I think that is the whole essence of deferring it. To continue the debate, many of us will rather debate it here. So I think my distinguished sisters should agree that these are the rules.
I'm not a spirit to know what the senator wanted to say. The senator said, I want to say something. But if I knew, I would have referred her to Rule 52, sub 6.
All right, that section, Akpabio went on to rule her out of order. But I must say that he did show grace. But, you know, Natasha being a woman, I believe, should have been given the floor to speak. I watched the proceedings and debate, and she appeared to have been calling to speak before the debate for minutes before that debate was closed. The bill was subsequently referred to the Senate Committee on Judiciary and Human Rights for further review. However, we're getting reports that women groups are planning to issue a statement to stop the review and demand a public hearing instead, objecting to the passage of the amendment. Now, when you look at some of the sections of the abortion clause in the Criminal Code Act, it appears quite controversial and confusing. I did look at it. For example, let's read that section 4 of the amendment of section 230 on supplying drugs or instrument to procure abortion. Section 230 of the Principal Act reads in part, any person who unlawfully supplies or supplies to or procures for any person, anything, whatever, knowing that it is intended to be unlawfully used to procure the miscarriage of a woman, whether she is or is not with child, is guilty of a felony and is liable to imprisonment for 5 years. I mean, this is such a huge debate. This debate highlights, the controversial nature of abortion legislation in Nigeria. Ayo, before I come to you, I'd like to take some reactions on X. But like I read in that section, the idea of miscarriage of a woman, I mean, that's, that also probably was what she was trying to debate. It's not miscarriage of a woman, it's miscarriage of a fetus. There is nobody that willingly wants to miscarry a child. It's an involuntary action, correct? But let me take some reactions on X. This person wrote, Senator Natasha has a valid point. Issues like abortion affect women directly, and her voice deserves to be heard. Silencing her only shows how male-dominated the system still is. Rule of order or not, the Senate should at least listen when a woman speaks on issues like this. Another X-user wrote, abortion is not the only sensitive thing discussed in the House, but the rule must be followed. There is a channel everyone in the House can make points when a case has been closed. She was not silenced. The House was just reminded of the proper thing to do. Another ex-user wrote, we don't have many women in the National Assembly, and since it's a deliberation on a topic that concerns women, she should have been given the chance to air her views. Rule or no rule. Finally, an ex-user wrote, see men talking about abortion like they get pregnant. That was actually my favorite ex. But this is such a big topic. Yes. Worldwide, in the United States, senators get removed for, some controversial comments about abortion. But like I said in my opening statement, I believe that she should have been given the floor, even if it was for 30 seconds. Yeah. Senate President Godswill Akpabio heard her and was about to give her the floor until Senator Oshiomhole intervene.
Okay, so what I want to interpret from that interaction is that Senator Oshiomhole is a stickler for rules, irrespective of what happens. But there's such a thing as discretion. And I believe that it is in the power of the Senate President to have discretion as to, okay, this matter, even though it's been stepped down, because of the nature of it and the fact that we have only 4 women in the Senate. Senator Natasha Akpoti-Uduaghan, Senator Ekpalibo Banigo, Senator Idia Toluranti Adebole, and Senator King Igwe. 4 of them. Out of the 4 of them, 1 woman has consistently had her voice, tried to have a voice in the Senate. I don't know why. I don't know where the other 3 senators are. Maybe we should also spotlight the fact that despite the fact that women are disproportionately not represented in the Senate, we don't even hear the voices of those ones represented. I like the fact that you noted that she had raised her hand earlier whilst the debate was still going on, and this is not the first time. We don't want to make it seem as if it's a victimization as a result of what had transpired prior. I don't want to say that is what is happening. I don't want to believe that is what is happening, because that's a hallowed chambers. I want to imagine that they'll be very professional. Now, on a topic like this that involves women directly, at least one female voice ought to be heard.
I think one person spoke and backed the amendment, saying that it should be increased to 5 years. The felony punishment or the punishment should be increased to 5 years.
Yeah, but no, in terms of for the abortion conversation and nitty-gritty of it, I believe that what the Senate President did initially by using his discretion to say, okay, you know what, speak up, and then was in order.
I thought so
we understand the rules, and people talk about rules and rules, but rules are made for the people and to enable a smooth running of the process. In extenuating circumstances like this, where you feel that the conversation will be made richer or be made robust and it's more inclusive, especially by the primary stakeholders, I thought that at least that discretion ought to have been extended to her. And this is also to make a bigger plea for ensuring that the voice of, this is not Senator Natasha Akpoti anymore. This is Kogi Central speaking. They must recognize that.
Yes.
Because when you silence the voice of one person, you're not just silencing her voice, you're silencing the voice of an entire constituent. You're silencing the voice of an entire demography, which is the women of Nigeria, whom only 4 of them out of 106 of them represent. And so I think in that regard, that ought to have been done.
Yes.
That's what's simple.
In all fairness, quick comment. I commend Senator Akpabio because he exercised that discretion.
He did. A lot of grace.
He did very well.
It doesn't mean that if he does otherwise, I will not say it. I will say it. But on this, I commend Senator Akpabio.
Yes,
and I don't think Senator Oshiomhole should have just come in there. He just allowed the woman to speak.
That is it. But now the matter has been, pushed to a judicial review. Like I said, some women groups are trying to...
Town hall. Let's have
that's
public,
what they're asking.
That's what
the women
they should have that.
Want a public debate. The matter should not be debated by only men and just 4 women and all of that. There should be a public debate and all of that. But we will follow up on the story. But also kudos to the senators for bringing these sort of sensitive issues to the floor of the House.
After watching that riveting segment, it's clear Nigeria's legal and social landscape is a complex and often contradictory space. Let us break down some of the key discussion from the Arise News Morning Show. First, we delved into the unfolding drama surrounding Nnamdi Kanu's defense, his decision to personally file a motion and list 23 high-profile witnesses, including former ministers and the governors, is a significant strategic shift. The move, coming shortly after his lawyer's remand, suggests a direct confrontation with the charges, moving beyond the procedural challenges that have characterized his case for years. The sheer number and caliber of witnesses indicates a robust, albeit delayed defense aiming to contextualize his actions within a broader political narrative. Then we heard Rufai Oseni's passionate critique of the sub-judice principle, questioning its inconsistent application. He highlighted instances where political leaders and public figures have openly discussed ongoing court cases, including previous attempts by Igbo leaders to secure a political solution for Kanu under President Buhari without facing the same sub-judice restrictions. This raises a crucial question. Is the rule of law being applied fairly and consistently across the border, or are there selective interpretations that serve particular interests? Rufai's argument points to a perceived hypocrisy, suggesting that if political solutions are deemed acceptable for some, they should be considered for all. The discussion also touched on the heated debate in the Senate over a controversial abortion clause in a criminal code amendment bill. Senator Natasha Akpoti-Uduaghan's attempt to revisit the clause was shut down by Senator Oshiomhole on procedural grounds. This incident sparked further debate on parliamentary rules versus the imperative for inclusive discourse, especially on issues that disproportionately affect women. Women's rights advocates argue that silencing female voices on such critical matters, even under the guise of procedure, undermines democratic representation and exposes the inherent biases within traditionally male-dominated institutions. Finally, we wrapped up with the bewildering case from Sokoto State, where a magistrate court ordered 2 TikTokers to marry within 60 days following the circulation of incident romantic videos. The Nigerian Bar Association swiftly condemned this ruling as unconstitutional, stressing that marriage is a voluntary union and cannot be imposed as a form of punishment. This decision highlights the ongoing tension between religious laws, state authority, and the fundamental human rights in Nigeria. Many see it as a clear overreach by Judicial, violating individual freedom of expression and association. Now, for my critical take. The issues raised in this segment are not merely isolated incidents. They are symptoms of deeper systematic challenges within Nigeria's governance and legal structure. The Nnamdi Kanu's case, particularly the sub-judice debate, exposes a fundamental weakness in the consistent application of legal principles. If courts and political actors can bypass established protocol for some, it erodes public confidence in the impartiality of justice. The call for a political solution for Kanu, mirroring approaches allegedly offered to bandits, underscores a disturbing trend where criminal justice is politicized, leading to a perception of selective justice based on influence rather than equity. This undermines the very foundation of the rule of law and risks turning the judicial system into a tool for political maneuvering rather than an impartial arbiter. The Senate's handling of the abortion bill, specifically the silencing of Senator Natasha, is another problematic point. While parliamentary rules are essential for order, their rigid application in the face of sensitive gender-specific issues can be counterproductive. It creates a barrier to comprehensive debate and marginalizes voices that need to be heard. A truly robust democratic system should encourage, not stifle, diverse perspective, especially when legislation directly impacts the lives and bodily autonomy of a significant demographic. The debate surrounding abortion, in particular, requires nuanced understanding and input from all stakeholders, especially women, whose lived experiences are paramount. In conclusion, this conversation from the Arise News Morning Show are a stark reminder of the critical work needed to strengthen Nigeria's democratic institution, upholding the rule of law, ensuring equitable justice, fostering inclusive governance, and protecting fundamental human rights are not just ideal, they are non-negotiable pillars for a stable and progressive society. The public deserves transparency, consistency, and a judiciary that acts without fear or favor, always prioritizing the Constitution above all else. What are your thoughts on these critical issues? Share your opinion in the comments below. Don't forget to like this video, subscribe to Obas Trending Gist for more in-depth analysis, and hit that notification bell so you never miss an update.